Good evening. Welcome to another program presented by the Law Related Education Committee, or LREC, as part of the Citizens Law School. My name is Tom Ebzery. I'm a Billings attorney and member of the Montana State Bar and the LREC Committee. What is the purpose of the Citizens Law School? LREC believes, as does the State Bar, that the purpose is to make our legal system more accessible to non-lawyers and provide an educational opportunity for Montana citizens. Program tonight on family law is an opportunity to understand the topic, and our speaker is clearly qualified to give you a 1-hour presentation. Sara Berg is a partner and shareholder in the Helena office of Browning, Kaleczyc, and Hoven. Her specialties include, of course, family law, divorce, child custody, as well as a medical malpractice defense practice. Sara was born and spent her early years in Big Rapids, Michigan, attended and graduated from Miami University in Oxford, Ohio, and then headed west to Missoula to attend and graduate from the University of Montana Law School. She has been with BKBH for over 22 years. As a mother of 3 active kids, she has succeeded in the juggling exercise of parenting and providing quality legal advice to her client base. She is active in a number of civic organizations in Helena and currently works with the Montana Legal Services to family law clients. I present to you Sara Berg to discuss family law.
Thank you, Tom. That was too kind, very generous. I appreciate the introduction. And thank you for all of you that are on the line. I can tell you that during the course of law school, we did lots of kind of trial practice. So we did trial practice arguments or oral argument practice, different sorts of presentations. I never, ever practice presenting to a crowd that I cannot see and cannot hear. So this is a unique experience for me. I hope that you can make it as interactive as possible. So if you have questions or you have comments, please weigh in on the Q&A or on the chat. I would very much like for you to get whatever information you're hoping to get from this presentation. And if that means you have to ask me for it, please do that. So Tom's going to kind of keep an eye on that Q&A and do not feel like you're interrupting. I'm hopeful that this can, like I said, be as interactive as possible because it is tough to present when you can't see anybody. I've been asked to speak about family law here tonight. Obviously, the umbrella of family law is pretty broad. It includes lots of things. It includes adoption. It includes common law marriage. It often dovetails with issues involving child protective services or youth in need of care. I can tell you that 95% of the practice that I do in family law, and what I'm going to talk about primarily tonight, is what I would call milquetoast, divorce, and parenting. So just kind of everyday folks like ourselves that want to dissolve their marriage and or need assistance with creating a parenting plan for their kiddos. And so that's kind of what I'm going to talk about tonight is the dissolution of marriage and parenting plans, because when I'm representing people, as well as when I'm approached in public by people with questions, that's 99% of the time, that's what they want to talk about. Several times in kind of anticipation of this presentation, I sat down to generate some PowerPoint slides, and I never quite could figure out how to have a PowerPoint slide that I didn't just read. And I'm not a huge fan of when people just read their PowerPoint slides to me. So instead of approaching this like a presentation where I'm doing PowerPoints, I instead decided to approach it a little bit more like I would in an initial consultation. So oftentimes I get a call from somebody that wants to come in and have an initial consultation with me about divorce and parenting that doesn't even know if they're going to get divorced yet, right? They're in a marriage that's struggling and the word has been thrown out either by them or by their spouse. And so it's floating around. It's kind of a tough one to suck back in once you've thrown it out there. And they're concerned about what is it? What does it look like? How does it work? How does it even happen? Because obviously going from a nuclear family in one household with kids to somehow being divorced and having everything in separate names and separate accounts and co-parenting, there's a lot that has to happen, and most people aren't familiar with how to get from point A to point B. So I do a lot of consultations with folks that just want to know what does it look like? How does it work? And what are the kind of substantive mechanics of dissolution and parenting? And then also, what are the procedural mechanics of dissolution and parenting? And so that's kind of how I thought I would approach tonight, is just to speak to all of you the way that I would speak to my clients in the event that we're having an initial consultation about just kind of how this works and what it looks like. And again, in those initial consultations, the clients often interrupt and ask me questions. So I'm hopeful that you will do the same here this evening. But when someone comes in and asks me about, I'm thinking about getting a divorce, and I do or don't have children, what does that look like? Usually one of the first things I say is that a dissolution, and it involves primarily two things. One, we got to divide up your stuff, right? We're going to divide up your debts and we're going to divide up your assets. And two, we got to figure out how to parent your kids. Usually we're going to look at residential schedules, so where they're spending their time, child support, and who's paying for health insurance. And so, those primary two things, dividing up stuff and parenting kids. The idea with the process, the way that I approach it, and I think most of my fellow family law practitioners approach the process, is to have the parties actually be the ones that make those decisions, right? Ultimately, the parties decide how to divide up their debts and assets. Ultimately, the parties decide how they're going to parent their kids, because the other people involved in the process, and ultimately the judge, that they don't know anything about the parties' finances or the kids, and really are not the ideal person to make those decisions. The ideal person to make those decisions are the parties. And so the process is kind of designed to try and provide some support and scaffolding to parties and help them as best as we can to do it themselves. Every once in a while I'll get somebody that will come in and just say, well, I just want the judge to do it. We're going to fight about it. We'll never figure it out. I just want the judge to do it. And usually when that happens, I'll look outside my conference room window and point at just a random person and say, well, how about we just grab them? Let's just ask them to make decisions about your money and your kids, because ultimately that's what you're going to ask the judge to do. You're going to ask somebody who doesn't know you from Adam to make decisions about your money and your kids. So instead, let's engage in the process and see if it's something that you can figure out, because you're really the best person to do it. So in terms of, but we take it just one step at a time. It tends to be a relatively volatile process. And so we just try to take one step at a time. And to the extent we can limit how much court involvement we have, we do that, because it's faster and it's cheaper and it's less adversarial. But if the process changes at any point during time, or the dynamics change between the parties, then we can add in or take out court scaffolding to kind of help us along the way. And again, get us from point A to point B, which is ultimately a dissolution with a decree that's dissolved the marriage, a parenting plan to deal with parenting kiddos, and then a property settlement agreement that'll help divide up debts and assets. So in terms of dividing up stuff, because that's the first thing we do, is we divide up the stuff, right? The debts and the assets. If the parties can't figure out how to do that between the two of them, then ultimately what the law tasks the court with doing is to divide the marital estate fairly and equitably. And so often when I say that to my client that's sitting there for their initial consultation, the two questions that they want to know the answer to right away is number one, what is fair and equitable? And number two, what's the marital estate? So fair and equitable is the standard by which the court divides the marital estate in Montana if the parties can't figure it out on their own. So we are not a community property state. And in a community property state, kind of the default setting is that it's a 50-50 division. In a fair and equitable state, the court is tasked with dividing things fairly, which sometimes may mean equally. If you've got parties that are similarly educated, they have similar jobs, the earnings, similar salaries, they are similar in age, they both are healthy, then it's very likely that the equitable division of their debts and assets is going to be 50-50. But I always, as an example of a fair division of debts and assets that isn't 50-50, I always tell my clients about my parents, who got married in 1968, are still married. My dad was a lawyer and my mom stayed home. And so my mom was the CEO of our household, which of course allowed and facilitated my dad being able to work a whole bunch more than he otherwise would have been able to do. So when my parents, if they'd gotten divorced at age 50, after 25 years of marriage, with my dad working as a lawyer and able to earn a salary that in part was supported by my mother not working, and my mom earning no salary and being out of the workforce for 25 years, the division of that marital estate is not going to be 50-50, because my dad can go regrow whatever limb he loses in the divorce, right? My mom can't. So that fair and equitable division is going to look much more like a 80-20 or 70-30. And so that fair and equitable is a standard. You look at the specific situation of the parties, and we try and figure out what would be a fair way to divide what the parties have and what the parties owe. This is where sometimes this is a tough concept for folks to understand and wrap their head around. Like I just mentioned, my dad was a lawyer, practiced 50 years before he retired, and it's a concept he still can't wrap his head around. So, but is that divorce is not a retrospective process. Divorce is a prospective process. So, but what the law assumes is that the parties, when they get married, they're competent adults, and they have made a decision to join and make decisions about what's good for the order and not necessarily what's good for individuals. And so you can't make it like it didn't happen. So the analogy that I always give clients is, when you come to your marriage, into your marriage, you are the blue crayon, and everything that you have is blue. You have a box of blue crayons that comprises who you are and what you have and what you owe. And your spouse is a box of yellow crayons. And what you do is you dump your crayons into a giant pot and heat it up and stir it around, and it turns into a green liquid wax, right? And then you come to me and say, now make me a blue crayon again. And you really can't. You cannot undo it as if it's never happened. And so instead of trying to undo it as if it's never happened, because you can't, instead, what we are looking to do is accept that what we have now is a big pot of green wax, and we're going to try to divide that green wax fairly so that people can go on back about their merry way. But can't ever go back to just the blue crayon. So it really it's that prospective process, and looking at where the parties are and the decisions that they've made helps us determine what's a fair and equitable division of that marital estate going to look like. And like I said, oftentimes it's 50-50, but depending on the situation of the parties, it can be very different than that. The second question that kind of comes from that is what comprises the marital estate? What is the marital estate? And basically, the marital estate is every debt and asset that you've acquired during the course of the marriage. And sometimes this too is a tough concept for folks to wrap their head around, because they come in and say, well, but this is in my name, so it's mine, right? Or it's my retirement, I earned it. Or, well, I bought that, and so that's mine. No, that's not how it works. So if it happened during the course of the marriage, if you earned it, if you spent it, if you accrued it, if you became obligated for it during the course of the marriage, with very few exception, it's in that pot, right? It's in that pot of green wax of everybody melded together. And so it's going to be something that gets considered when how we figure out how to divide things. And so people always want to know, well, what's in the marital estate, right? What's in the marital estate? Usually the questions are my guns in the marital estate? Are my mounts in the marital estate? And then the fifth wheel trailer, because I always say that we really can't have a divorce in Montana unless there's a fifth wheel camper involved. But what do we do with the guns and the mounts and the camper? And really the answer is, when were they purchased? Were they purchased during the course of the marriage? Because if they were, they're in the pot, and they're what we talk about in terms of how we divide things fairly. There are some things that are not in the marital estate that fall outside of that pot. The first one is premarital assets, right? So if you come to the marriage with a premarital asset, you have a 1971 Camaro, that's your pride and joy, and you get married and you keep the Camaro and it stays all nice and covered up in your garage. And then when it comes time to be divorced, you still have the Camaro. You can argue that Camaro falls outside of the pot of green wax, right? It's not something the court gets to divide. It's yours because it came with you to the marriage, and it's still there when you're ready to dissolve the marriage. Similarly, Inheritance is something that can be considered a non-marital asset, or something that people have that's not marital, that would fall outside of that pot of wax that the court ultimately has to divide. There's some arguments, depending on the situation of the parties, that student loan debt is a debt that would fall outside of the marital estate, simply because the education that comes with the student loan debt stays with the person that got the education, so they should get to keep the debt. But those things are really, it's the exception and not the rule. Generally speaking, anything you earn and anything that you obligate yourself to during the course of the marriage falls in that pot that ultimately is the responsibility and or ownership of both parties, and has to be divided fairly and equitably. Sometimes there are times where these non-marital assets, things like inheritance or premarital property, that they become marital. And again, if you think about that analogy of the crayons, is you have to be able to decipher something that's blue, right? The inheritance can't be mixed so much in the pot that it's turned green. The Camaro can't be melted so much into the pot that it's turned green. If you can decipher kind of the blue margins of a premarital asset or an inheritance, then you can cut it out and remove it from the marital estate. But if you've, brought some money to the marriage, put it into a down payment on a house that everybody lived in for 10 years, and then sold it, and then bought another house, and then sold it, and went on a trip, that money's been pretty well commingled into the greater pot. And it's going to be really hard to argue that it should be removed from the marital estate and not divided, or not subject to division. So the idea is then, so you identify that a marital estate is what ultimately gets divided. It's what we have to divvy up, and the things that are non-marital don't get divided. The court does have, and this gets a little complicated, and it's kind of hard to do without me doing a little simple drawing that I usually do, but the court can consider what parties have in terms of non-marital asset when they decide how to fairly divide marital asset. So the kind of the little vignette that I always use is, if you have parties that are married and their only marital asset is a house that's $100,000, and one party has no non-marital asset, they have no premarital asset, they have no inheritance, they just have this house that they own with their spouse. And the other party has a lot of premarital or non-marital asset, maybe a trust fund from when they were a baby, or an inheritance from a wealthy grandparent, or a lot of premarital asset that's been put in some sort of mutual fund or retirement. Then the court can look at that whole picture from that 30,000-foot view and say, you know what, since this one party has all this non-marital asset that they get to keep, and this other party doesn't, then I'm not going to divide that house up 50-50. I'm going to give the party that doesn't have very much the majority of that $100,000 house value, and the party that has stuff already a less amount of that house value, because that's what's fair. So non-marital assets aren't divided, but they can be considered when the court figures out how to fairly divide assets and debts that are marital. So we use that law, that fair and equitable law, and what constitutes the marital estate, the law of that, when we try to help guide the parties figure out how to divide their debts and assets between themselves, right? So again, ideally, the court doesn't divide up the assets and debts of the parties do that. And the lawyers help counsel the parties on what the law is, so that they can hopefully on their own agree to a division of the debts and assets that would look very similar to what the court would do if you asked the judge to do it. And that way, that everybody's kind of getting a fair shake, because it looks like what it would look like if we asked the court to apply the law to the facts of this particular marriage. So that's kind of how we try to work on dividing up assets. That's a law, kind of the substantive mechanics of dividing up debts and assets is that it's a fair and equitable state, and we try to fairly and equitably divide the marital estate. So how do we actually go about dividing it? Well, the first thing that you have to do if you're going to divide up a universe is identify the universe. And so the parties are each asked to complete a form called a declaration of disclosure. It's a form that's on the internet, on the Montana Supreme Court website. Lots of parties do their own divorces. And so it is something that there are forms and paperwork on the website for the courts that you can use to try to facilitate your own dissolution if that's the route you want to take. But you have to identify the universe. So you fill out this form and it's a declaration of disclosure, and it says, here's everything I have, and here's everything I owe, and here's what I make every month, and here's my monthly expenses. And each party has to fill that out and sign it under oath. And then they have to exchange it. And so the idea is, when you're trying to figure out how to fairly divide up that universe, both parties know what the other party says they have. And that's kind of how the court makes sure that as best as we can in a civil process like dissolution, that nobody's hiding a Renoir in the basement or sold the house to their mom for $1 and then they're going to buy it back after the dissolution is finalized. It's if you're willing to lie about what you have or what you owe, you're doing it under oath. And so that's kind of a quality control check, for lack of a better term, in terms of that declaration of disclosure. So the declaration of disclosures are exchanged, and then and the parties try to assess what they have and what they owe and what are the values or amounts that they owe associated with those debts and assets. And you can do that a number of different ways. Some people just kind of by consensus agree and just say, okay, let's just agree that your blue car has the same value as my red car. And then you'll get the blue car and I get the red car, and all is well. Some parties want a little bit more scaffolding. Like I talked about, you just kind of add in support and scaffolding to help the parties through the process. They want Kelley Blue Book values, right? And they say my Kelley Blue Book value on the blue car is $2,000 less than your Kelley Blue Book of the red car. So you owe me $1,000 to even things out. And you really can do whatever it is that the parties feel comfortable. It's their process. And as long as they feel like the ultimate end is a fair and equitable division of what they have and what they owe, they're allowed to decide how they determine the values of things. But for vehicles, we usually use either consensus, like I said, or we use Kelley Blue Book values or something along those lines. For tangible personal property or stuff, we usually kind of use garage sale value. So if you stuck it out on the street corner, what would somebody pay for it? And that helps because just give people ballpark values on things in terms of who's going to get the upstairs furniture and who's going to get the downstairs furniture. Real estate's a little trickier, obviously, especially right now because the market's so wild. But typically, again, the parties can just agree. They can agree, hey, we think the house is worth this much, and divide the equity up accordingly. Oftentimes, parties will get CMAs, comparative market analyses done by real estate agents. They're usually pretty fast, and usually the real estate agents will do them for free. It gives an idea of what an asking price for the house would be. And the parties can agree to use the CMA as the value for the purpose of figuring out what equity is. Or you can get an appraisal done. That's kind of considered the gold standard because it does require a licensed appraiser to go ahead and perform the appraisal. And then usually that value would be accepted by the court as what the house is worth. And the parties can either put the house on the market and sell it, and decide how to split the proceeds. Of course, that's the only way to really determine what a house will sell for, is to sell it. Or they can accept a value, like I said, by consensus, or with a CMA or with an appraisal, and one party can refinance the home and purchase it from the other party, right? Buy the other party out of their equity. And that's something that we do very, very frequently. Typically, if one party really wants to keep the home and the other party doesn't, the court will, or we try to draft into the documents, the opportunity for the party that wants to keep the home to try and refinance the property on their own. And then only in the event that they cannot do so, that the bank won't do it, do we list the house and have it sold. But real estate, those are the ways that we tend to value real estate. Retirements also are a little bit tricky in terms of how they're valued. Obviously, defined contribution plans like 401ks and IRAs, their value is their balance. But pensions or defined benefit retirement accounts, their balance, their value is much more difficult to determine. Typically, when we have a pension, if the parties can't just kind of agree that, you know, you get your pension and I get mine, or you get your pension and I get this IRA, in order to accurately value the pension, we'll hire a financial person, often an accountant, to do a present day value calculation of what that defined benefit or pension is actually worth today. And that present day value calculation is what the court uses if the parties can't agree on how to divide it. We do have tools with retirement accounts so that folks don't have to suffer tax consequences from retirement tax-free or tax-protected accounts in terms of the dissolution process if they don't want to. We have a vehicle called a Qualified Domestic Relations Order. It's quadro, and it allows one party to, in a dissolution setting, to roll money from a qualified retirement account to another qualified retirement account without anybody being penalized. So if my retirement account has $50,000 and I'm gonna transfer 25 of that to my soon-to-be ex-spouse, he can open a 401k and I can roll half of my 401k into his 401k. And then we both just have a 401k and no one suffers any tax consequences either from the withdrawal or the setting up of the account. And then if anyone does want to withdraw from those 401ks, those tax consequences are their own and the other spouse doesn't have to suffer them. So we do have some tools that we can use to help folks divide things up. How, you know, cash is easy, right? Cash is king, it's liquid, it's easy to divide. But it is a little trickier when you're talking about tangible asset, vehicle, real estate, and retirement. But we do have some tools that we use to help folks figure out how we best divide those things up in a way that's fair and equitable. Then ultimately, after you've exchanged your declarations of disclosure, and so everybody knows what everybody has, and you've tried to figure out some values, then ideally you're able to negotiate an agreement, and that agreement that divides up debts and assets is called a marital and property settlement agreement or property settlement agreement. Then it's a contract. It's just a contract between the parties that says this is what we have and this is what we owe and this is how we're going to divide it up. And we think it's fair. And when the parties sign it, it becomes a contract between the two of them. Then what we do is, as part of the dissolution process, because the court does have to dissolve the parties' marriage, we file that contract and we ask the judge, please divorce these parties pursuant to this contract and make it a court order as part of the decree of dissolution. And unless the property settlement agreement is unconscionable, unless the court finds that it is so unfair that it's not an appropriate contract, most of the time the court is very happy that the parties have been able to reach an agreement on how to divide their debts and assets, and are more than happy to create, to incorporate it into the decree of dissolution and make it a court order. The property settlement agreement also contains kind of all the little actionable items in it, boilerplate terms that are in every property settlement agreement, you know, how to transfer titles, when you have to close bank accounts, how to deal with credit cards. So the parties kind of get a little list of action items after they enter that agreement, and they start doing things like putting the Jeep in his name and the Focus in her name, and closing this credit card account, or shutting down or taking somebody's name off this bank account. And the property settlement agreement kind of provides them that little list of the things to do in order to make sure that your debts and assets can be appropriately divided, and from a kind of tangible stuff perspective, people can start to live separate lives as a divorced couple. Generally speaking, what the court tries to do is, again, divide the marital estate fairly and equitably so that people can go off on their way. Part of the public policy behind that kind of fair and equitable division is the idea that you want to make sure that decisions that the parties have made as a married couple, that once they're divorced doesn't mean one party is financially sound and the other party now becomes the responsibility of the taxpayers, right? And so what the court tries to do is use what the parties have in their marital estate and divide that in a way that allows that to be the case. So like the example that I gave of my folks, you know, my mom would get a much larger percentage of that marital estate because that ensures that then she's not going to be the responsibility of the taxpayers while my dad goes and earns a lawyer's salary. But sometimes the marital estate isn't enough. There's just not enough in the marital estate, or it's the way that it's configured doesn't allow for a division that lets both parties go on their merry way, right? And so in that case, then we look at the option of maintenance. Maintenance is the newer term that we use for alimony, which is spousal support. It's completely different than child support. Child support is for kids, spousal support is for spouses. But maintenance is on and beyond the division of the marital estate. Then a portion of money is paid from one spouse to another in order to, again, facilitate a fair and equitable dissolution that allows everyone to go live independent lives and again, not be fallen on hard times and be on the state's dole, so to speak. So maintenance is disfavored in Montana. The laws about alimony, about maintenance vary quite wildly actually from state to state. Some of the older states and the East Coast have lifetime alimony laws still on their books. We do not. We disfavor maintenance because, again, we want, to the extent possible, the parties to be able to dissolve their marriage and be completely separate as of the time of the decree of dissolution, as opposed to continuing to be financially connected, if at all possible. But it is considered in circumstances where it's appropriate. Typically, you're looking at long-term marriages, so marriages that are over 10 years. You're looking at issues where the parties are pretty disparate. So their incomes are very disparate. Maybe their health is very disparate. Their ages are disparate, or their levels of education are very disparate. And so those are circumstances in which you might look to maintenance to kind of augment someone for a short period of time following a dissolution. Oftentimes it's a launch back into the workforce. So if you have one spouse that hasn't earned an income or hasn't been in the workforce, they will get an augmentation, a spousal support award for the 3 years that they're going to be going to nursing school, or the 3 years that they have to renew their teaching certificate, or the 3 years it takes to kind of build up seniority at a specific employer place that they're going to return to the workforce in. So usually when maintenance is awarded by the court, it's something that's tied to a particular purpose. And there are statutes that govern when maintenance is or isn't appropriate. And it's a relatively high threshold here in Montana. Most of the time we try real hard to make sure that we divide the marital estate in a way that allows people to dissolve their marriage and go on their way, as opposed to looping in maintenance. But I mean, anybody that practices family law hears people ask questions about alimony all the time. So I wanted to make sure that I at least touched on it this evening. So that's really kind of the summary of dividing up debts and assets. It's a fair and equitable state, and we divide up the marital estate equitably. We disclose all of that with declarations and disclosures and try to assign values, and we try to negotiate ultimately a property settlement agreement that's a contract that's ultimately adopted by the court as an order as part of the dissolution. If I wanted to kind of take this opportunity, if anybody had any questions about kind of the property aspect of dissolution, the dividing up stuff, this would be a good time to ask before I move on to parenting. Any questions? Is everybody awake? Probably everybody's asleep right now. So if there are no questions, I'll just move on to the next thing, which is the parenting. Like I said, when you're getting divorced, primarily there's two things that you have to do. The first one is divide up your debts and assets, divide up your stuff, right? And the second thing is, if you have kids, you got to figure out the co-parenting arrangements for your kids. And usually that parenting arrangement includes primarily a residential schedule. So where are they going to be and when are they going to be there? Who's going to pay their health insurance, and what does child support look like? The fourth thing that you're going to see in a parenting plan is all the other stuff, right? Decisions, rules, agreements, things like, how are we going to make decisions about where they go to school? How are we going to make decisions about the religion that they're raised in? How are we going to decide if we let them have a tattoo? Those kind of things are the other parts that make up the rest of the parenting plan. What's really, I think, interesting about parenting plans that most people don't know is that parenting plans is actually a limiting document. It's not a document that it gives you something. It's actually a document that takes something away. So when you're a parent of a child, every parent has the right to be with their kid 100% of the time, unless you've got a court order that says otherwise. And that's what a parenting plan is. It's a court order that says otherwise. Oh, I see there are 2 QAs. Let's see what those are. I'm going to pause for a second and see if I can see what those are. Oh, good. Anna's awake. That's great. And then Paul asked, does the court ever allow for arrangements like allowing a period of time for one spouse to qualify for the refinance? Absolutely. So typically the banks won't even consider begin the paperwork or the refi analysis until the divorce is finalized. So you can go to the bank and get some general, yeah, you might qualify, you might not, but the process can't really officially begin until the divorce is finalized. And so once the divorce is finalized, the party that wants to refinance the house and purchase the other party out of their equity needs some time to figure out if they can do that. That's going to depend on an analysis of their income earning potential, their debt to income ratio, all those things that the bank considers when anybody refinances, whether you're a single person or a married couple. So we usually, what we do when we're drafting property settlement agreements that involve a potential refinance is we draft a contingency. So we say, Joe gets 120 days to refinance the home and remove Susan's name from the mortgage. And Susan will cooperate with this process, executing any and all paperwork, including but not limited to a quitclaim deed, as part of the refinance process. And within, during that 120 days, her name gets removed from the mortgage and she's paid X amount of dollars that represents her equity in the home. If after 120 days, Joe has not been able to accomplish a refinance, then the home is immediately listed for sale. And that's typically how we deal with it. It just gives people the opportunity to try and refinance the house. And then if they can't, then the house gets listed for sale typically. But really, again, it's every party gets to make their own choices about how this works. It really is whatever the parties can agree to. So you can have like a double contingency. You can have so-and-so gets the opportunity to refinance. And if they can't, then the other party gets the opportunity to refinance. And if they can't, then the house gets listed for sale. Sometimes we have situations where we know a party is not going to be able to qualify to refinance. Maybe a stay-at-home parent that's trying to re-enter the workforce, they're not going to be able to qualify. But both parties agree that they want that party to be able to stay in the home. Maybe the kids, that's the kids' home base. And so party A is willing to stay on the mortgage for a period of whatever time, 3 years, 5 years, whatever parties agree to. So we try to see if we can come up with a situation that, again, allows parties to part ways as best as they can, as much as they can at the time that their decree is entered. But sometimes that's not possible in a way that still allows them to meet all their goals. And so when that's the case, then we work around it. Lots of people continue to co-own homes after they're no longer married. The deed is usually changed from being joint tenants with right of survivorship to just being joint tenants. But certainly lots of people co-own houses that aren't married. So we really try to use as many arrows in the quiver as we can get to try and come to an agreement that people feel good about and that resolves the issue and allows them to accomplish a dissolution without the court involvement. So hopefully that answered your question, Paul. If it didn't, just pop another one in the Q&A. But yeah, so kind of back to parenting. The parenting plan is a limited document. It prescribes what time each parent has with the kids. So it's not a document that gives you parenting time. It's actually a document that restricts your parenting time. Parents don't like to hear that, but I think it's important to think about what the document is doing and what it accomplishes, because I think it helps describe and emphasize why it's necessary. We have a lot of couples right now that never get married and have kids. And so when they decide that they no longer want to be together, they don't have to get a divorce. And so there is no kind of legal requirement for them to get a parenting plan. If you're legally married and you need the court to grant your dissolution and you have kids, The court will not grant your dissolution unless you have a parenting plan. So if you have a legal marriage, then to get out of that legal marriage with kids, you got to have a plan. But if you don't have a legal marriage, you don't need to have a parenting plan when you leave that relationship. And so there are lots of instances where we have couples that are no longer together, are co-parenting kids, and they don't have a parenting plan. And of course, the worst case scenario as a lawyer that you always think about for those folks is that one time one party just doesn't bring the kids back like they said they would, and they are in the wind. And there's no document that says that they can't be, because
I'm sorry.
Oh, sorry, Siri thought I was talking to her. I apologize. There's no document that says that they can't be with their kids. And so, the party that can't find the kids comes to the police and says, you have to go find my kids. And the police says, well, show me the document that says that their dad can't have them or that their mom can't have them. And if there isn't one, then that process has to take place before law enforcement can go try to retrieve the kids. And so it can be a really, really just traumatic and often catastrophic situation to not have a plan that law enforcement can go enforce that says, hey, you're not supposed to have the kids right now. She is, or he is. And so I think kind of describing it in the context of it being a limiting document is really important for people to understand why you should have one. If you're not married, legally married to your spouse, and you have kids, you should have a parenting plan. And so I think the purpose of it is important when you're thinking about that. The idea that we try to do when we're helping people through this process, whether they're getting a parenting plan in the context of also getting a divorce, or whether they're just getting a parenting plan, is to have the parents figure it out. Is to have the parents work through what that looks like, because parents know their kids better than anybody else, and they're the people that should be making the decisions for those kids. But again, what we do as lawyers is we kind of have the backdrop of the law, provide kind of, here's what happens if you can't figure this out, right? Here's what the court is going to do if you can't figure this out. And when it comes to parenting, what the court does is, for children over whom they have jurisdiction, which are kids that have lived in Montana for 6 months or more, they are charged with coming up with a parenting plan that is in the best interest of the child. And I'm sure even those of you that are on the Zoom right now that are not lawyers, you have all heard that phrase. It's a very familiar phrase to anybody that talks about parenting plans or family laws. What's in the best interest of the child? So what's in the best interest of the child is defined by statute, and then further defined or further examined by case law or common law. The statute is, and it's the only one I'm going to cite tonight, because I don't like throwing out statutes, but it's Montana Code Annotated 44212, and it lists all the different things that the court considers when they figure out what the best interests of the kiddos are. That list includes, it's not limited to, but the list includes, what do the parents want? At an appropriate time, what does the kiddo want? What are the interactions that the kiddo can have with parents, with siblings, with grandparents, in terms of their adjustment to their home, their adjustment to school, their adjustment to community, the mental and physical health of the parties that are involved in their parenting and support. If there's been any physical abuse or emotional abuse by a parent to a child, if either of the parent have any sort of substance abuse, and again, that substance abuse is defined by statute. It's like a statute within a statute. And then what continued stability for the kids, and making sure the developmental needs of the children are met. So when the court's trying to figure out, if the court has to figure out what's in the best interest of the kiddos, that's what they're looking at, or is kind of that list. And then they're going to try to come up with a parenting plan that accomplishes those things that are on the list. Generally, all things being equal, it's in the law in Montana is that it's in a kiddo's best interest to spend as much time with both of their parents as is possible. Now, sometimes that means that if possible and everything's equal, then you're looking at a 50-50 sort of custody, or residential schedule, half time with mom, half time with dad. But it could be that if dad lives far away or mom lives far away, that that spending as much time as they can with both their parents means means summer with one parent and the rest of the time with another parent. It looks different based on whatever situation, situational particularities that particular family presents. When we're looking at parenting plans for kiddos, we look at obviously where the parents live, how old is the kiddo, how many siblings do they have, how well adjusted are they, do they have one parent that they're super bonded to, does one parent have a work schedule that allows for more parenting than another. We really try to make it a custom fit every time. You can, again, just like with how you divide up your debts and assets, you can come up with whatever kind of parenting schedule works for you and your family. Lots of families, if they've got a parent that does shift work, their parenting schedule looks very, very different than other families. Typical ones, I'm sure you've all heard, week to week, 1 week on with one parent, 1 week with another parent. If kids are younger and it's hard for them to be away from parents for that long, we do 2-2-3s or 2-2 every other weekend. So mom always has Monday, Tuesday, dad always has Wednesday, Thursday, and we flip-flop the weekends. Allows for a little bit more contact for younger kids with both parents over the course of the week. There's kind of the old school is every other weekend, and then the parent that gets the every other weekend gets a whole bunch of time in the summer. But really, it's just the ideal is that the parents figure out what works best for their family and their kids, and they prescribe what that residential schedule is. If they can't figure that out, then again, the court uses that best interest analysis to try to figure out what they think that residential schedule is. And I just always encourage my clients, you don't want somebody that's never met your kids to decide where your kids spend their time. So take every opportunity and work as hard as you can to figure it out between the two of you, because otherwise you're asking somebody that doesn't know your kid to make that decision. Another thing that the parenting plan is going to cover is who pays for health insurance, and then also how child support is determined. Child support, what they've tried to do is take something that's historically was extremely subjective and often clogged up the courts because of its subjectivity, and make it objective. So Child Support Services Division, which is an agency of the state of Montana under DPHHS, has created it's an algorithm. We call it the guidelines or the worksheets, and it's a computer program. So you input information and it spits out a number for you. And obviously there's some judgment and some gray area in terms of what the numbers that go in are. But it tries to, again, make something that's been historically very, very subjective into something that's objective. So all of us that practice family law have the program on our computers. We can do it. Or you can ask Child Support Services Division to do it for you, and they'll assign an investigator who collects information, and they plug the numbers into the computer program and it spits a number out. So what we do in our process is much like when it comes to property, the parties are filling out declarations of disclosure. When it comes to parenting, we have them fill out what's called a child support affidavit. And it's similar. It says what the parties make, what expenses they pay for their kids in terms of like health insurance premiums or daycare expenses, things that are considered mandatory expenses, and who pays those, how much those are. And so that information we take from that child support affidavit and we plug it in and into that algorithm, right? So you plug in things like what people's wages are or what their incomes are, those mandatory expenses that are included on a child support affidavit, like insurance costs or daycare costs, and then the number of days that the kids are spending with either party. So if it's a 50-50 plan, then you're going to have 182.5 and 182.5. That information gets plugged into the algorithm and it spits out a number and says who's obligated to pay who, whatever amount per month. Again, it can be handled by the administrative agency. And so if you want to handle child support that way, there's a process within the administrative process to handle. If you disagree with the calculation, you can appeal that and have your matter heard before a hearing with an administrative law judge. And appeal that even to the district court. But the idea is it kind of allows for a parenting plan to be put in place and child support to be kind of a bubble within that parenting plan that can be dealt with on its own without having to disrupt all the rest of the parenting plan. And let's see. So, and then CSSD, which is the Child Support Services Division, they wear two hats. They can either figure out the child support for you, and then they can also collect it. So they can enforce child support orders, and they it takes a while, but they do have teeth. They can restrict people's licenses, your license to practice law, your commercial driver's license, all sorts of things if you don't pay child support. So they are an agency that is really, really helpful. And if you're someone that's having a child support issue, oftentimes your legal counsel is going to help you navigate that process with CSSD, because they really are the professionals in that area. The other stuff that you find in a parenting plan are the things I talked about before. How to co-parent, what kind of things you say to your kid, what kind of things you don't. Are you going to agree before you cut your daughter's hair, or does mom get to make that decision? What religion are the children going to be raised? How do you celebrate holidays? Where do you celebrate holidays? How do you navigate vacations? Who picks kids up and who drops them off? We try real hard when we're drafting a parenting plan. I always call it a constitution. It's like a living document, right? It has to be able to live and breathe, because it's going to change day to day. Anybody that has a kid knows that. So you have to draft something that gives the parties enough structure and scaffolding that hopefully they have an answer when they have a disagreement or they have a question. They can look to the plan and say, oh, here's the answer, right? But that it's not so restrictive that it has to be changed every 6 months, because you've got kids that are developing and changing and families that are developing and changing. So it's always a little bit tricky, but we try to make sure that it's got enough scaffolding to help people through the process, and not so much that it's a document that can remain relevant for them and their families for that period of time after. So let me see, what else do I have about parenting plans? Again, like property settlement agreements, parenting plans, if you can agree to one, are a contract between the parties. You sign it as a contract. It's at the second you sign it, it's a contract between those two parties. And then you ask, when you file for the dissolution with the court, you say, please adopt this parenting plan, and make it a court order as part of the decree of dissolution. You can amend a parenting plan too, outside of the context of a dissolution. It's a tall order. The statute regarding amendment of parenting plans says that there has to be a significant change in circumstances in order for the court to even consider amending the plan. So before you can even get to the court to ask them to change it, you have to meet the threshold of that significant change in circumstances. It's pretty tough. The case law that has come from that statute has said, even 10 years in and of itself doesn't constitute a significant change in circumstances. It really requires a significant change in like location or health or situation of the parties in order to have the court change the plan. Most parenting plans have an alternative dispute resolution built into them. So a mediation requirement that says, hey, if we ever want to change this plan or something's not working, before we go try to knock on the court's door and have them fix it, we'll agree to sit down and mediate it with a mediator and see if we can resolve the problem ourselves. And most of the time, even if it doesn't have a mediation requirement, the court will make you mediate. They want you to try as best as you can to solve the problem on yourself before you come ask them to do it. And that applies to amendments as well as it does to just creating a parenting plan. So in terms of the kind of just overall procedure, right? We've talked about the how we create a property settlement agreement, how we divide up stuff, right? How we create a parenting plan, how we parent our kids. So what are the procedural mechanics? Like then what the heck do you do? How does that all translate into going from being married people to being divorced people? And the procedure is we file a petition, right? So the first thing you do is file a petition for dissolution, which is just a written request to the court to dissolve the marriage. And it's real simple. It's this is who we are. This is when we got married. We need a parenting plan. And if we can't figure it out, Judge, we'll need you to do it for us. And we're going to need a property settlement agreement, Judge. And if we can't figure it out, we're going to need you to do it for us. That's all the petition says. It just asks the court to participate in the process, to initiate the process of dissolving the marriage. Once the petition is filed, the court issues a couple of things. The first thing that the court issues is what's called a temporary economic restraining order. And people always freak out because they hear restraining order, and restraining order is not to be confused with order of protection. A temporary economic restraining order just says, hey, while this process is pending, we're going to try to keep a financial status quo. So you can't go rack up a bunch of credit card debt. You can't go sell a bunch of your assets. We're going to try to maintain a financial status quo so that we can identify what the universe is and divide up those debts and assets, right? And so it doesn't mean you can't buy groceries. It just means that if there's going to be major purchases or major sales, the parties either need to agree, and if they can't agree, they have to get permission from the court. So it is a tool. Sometimes we do file petitions specifically so that we can get that TERO issued and kind of freeze things and lock in the universe. It makes it a little bit easier for us to divide if parties are real adversarial and the financial situation is real volatile. Then the court also issues an order setting a scheduling conference. The lawyers attend the scheduling conference, and the clerk, the judge's clerk, provides us with dates, right? And ultimately a date for a hearing on the merits, though we always aspire to not have to use that date. We want to work it out on our own. But have a hearing on the merits. And then the other dates that are included in there is a mediation. They try to make you work it out if you can't negotiate it informally. A date that you have to exchange your declarations of disclosure, and a date that you have to exchange your child support affidavits. And hopefully as you kind of proceed through that schedule and you get those documents exchanged, you can negotiate your property settlement agreement and your parenting plan. You ultimately file those with the court along with a proposed decree of dissolution. And used to be, we used to have to go up in person and have the judge grant the dissolution in person with at least one party. But post-COVID, we now are able to file what's called a joint affidavit requesting the dissolution be granted. And so the lawyers put together a little package of a joint affidavit, parenting plan, property settlement agreement, proposed decree, and we send it up to the judge, and usually within a week we get it back and it's all done. So that's kind of divorce in an hour. And we've got 4 minutes. So if anybody has any questions for me, throw them up in the Q&A. Look at that, Tom. It was so good. No one has any questions. They all know everything now.
Sarah, thank you. I think we've got a couple more minutes. It was wonderful. It was to the point, and I think everyone learned a lot. I think I see a question. Sarah, go ahead.
Let's see what the question is there. Oh, thank you. I appreciate it. I just got a fantastic. Also, so for any of you that are on the webinar, I think you probably got your link from Joe at the State Bar. If anybody has any follow-up questions for me or wants to talk to me about something, or please feel free to reach out to Joe. He can give you my contact information. I'm more than happy to chat with anybody or help point you in the right direction if you're looking for a resource in this area. Let's see, it looks like maybe we got another question here. Does the court order temporary parenting plans and child support orders? They will, yes. Sometimes if we've got a really volatile situation or an emergency situation, we can ask the court to either order an emergency parenting plan. That's one option. And then the second option that's a little less emergent, we call an interim parenting plan. So you have a parenting plan that kind of covers what's going to happen and how much child support or family support is going to be exchanged during the pendency of the process. So it may not ultimately be the final parenting plan that the parties agree to, but sometimes if we're having some struggles with how to navigate kiddos and co-parenting during the pendency of the process, we can get a temporary plan issued. I hope that answers your question. Any other questions? Okay, let's see. Here we go. Thank you. You bet, Paul. Thanks for attending. Is that the end? I can't tell. Let's see here. If they cannot agree, can the court force a long-term plan? Absolutely. So ultimately, if the parties don't agree, you ask the court to make the decision for you. And then the court issues a parenting plan. And so, sometimes that has to happen. I will tell you, I think it's a worst case scenario. We have wonderful judges in Lewis and Clark County, and they are so thoughtful and purposeful and work really, really hard to get the right answer. But it's really hard to make decisions for kids that you've never met and families that you've never met. And so, boy, I always encourage my clients, if there's any way to figure it out, short of having the judge figure it out for you, that you want to take that opportunity. Let's see here. What is dissipation? Dissipation of assets is like a spending down of assets. So that's one of the things that the TERO is designed to eliminate. Is you don't want somebody to kind of spend away assets or spend away liquid cash, right? I mean, it's if somebody takes a bunch of money out of a bank account and spends it all, then it's gone. And if they can't recreate it, it's really hard to hold them accountable for that in terms of dividing up the marital estate. So the TERO, that temporary economic restraining order, is designed specifically to prevent the dissipation of assets. Let's see here. After canceling child support, if a child is 10, when can you ask for support again? So that depends. If you've utilized Child Support Services Division to calculate your child support, once they
didn't find anything on the web.
Sorry, Siri really likes this presentation. If you then once they calculate for that for you and they issue a final order, then you can have that recalculated either if there's a significant change in circumstances, which is typically defined at like a 30% income swing, or every 3 years for no reason at all. If Child Support Services Division has not calculated your child support, you can apply for that to be recalculated at any time. So if parties like informally agreed, hey, we're just not going to do child support, I'm not going to worry about it, and then 2 years later somebody is really hurting and needs support, they can absolutely go and apply with CSSD, and they can go ahead and try to calculate a child support award.
I think we've cleared the decks. Sarah, thank you so much on behalf of
Thank you, Tom.
LREC, and you did a wonderful job. And I think those, and they'll be able to pick this up since it's been recorded, correct? Okay.
Yep, I think they're posted on the website. And like I said, if anybody has any questions that they think of later, feel free to shoot me an email.
Well, again, thank you on behalf of the State Bar and LREC. We'd like to give you something in terms of a presentation, but by Zoom, we don't do that anymore. So you're just going to have to accept our thanks. And
that's more than enough.
Okay,
I appreciate the opportunity.
All right. Good night, everyone.
Thanks, everybody. Bye-bye.